Okay. Well, first of all, thank you, Marina and Caroline and others for inviting me to be with you all this evening. And thank you to so many for taking some time to come together and hear about and discuss and ask questions about this bill. I'm going to talk for a bit. I will try and control myself. I can sometimes talk too much, and there is a lot that can be said about this bill, so it will be particularly hard to restrain myself. I thought what I would try and do is answer a few sort of general questions, which I'm going to flag at the beginning, not necessarily in the order that I flag them, but so you've got an idea of where I'm trying to go. And then obviously I'm very happy to try and answer questions towards the end. But some general questions about the bill that I thought maybe it would be helpful to frame this around is, given perhaps what Marina has just said, actually, why is it that Amnesty has not called for the wholesale bill to be scrapped? I think might be one question that people may be interested in. And similarly, a related question as to why Amnesty, unlike others, has not formally dubbed this bill the anti-refugee bill, which I know is a favoured phrase by many campaigners. What in this bill, if anything, and there are some things, does Amnesty approve of? And you know that may raise some eyebrows given the contents and general discussion of the bill. What, and this is particularly important, I think, what in the bill concerning refugees and asylum, what's there and what does it do? And finally, perhaps who else is affected by this bill? So those are the sorts of questions I hope that at the end of our hour or so, we'll be in a better position to answer. If I start with the general question about why Amnesty has not called for the bill simply to be scrapped, which relates to the question as to what in it do we approve of. The short answer to that is that Amnesty supports the first 8 clauses in this bill. They don't relate at all to refugees and asylum. They don't really relate to the immigration system. They relate to nationality law. And as I'm sure we're all aware, it's a Nationality and Borders Bill. And in fact, the first 8 clauses of the bill concern nationality law. And there are 2 of those now, those clauses, that we have very grave human rights concerns about too. But the first 8 clauses, which I won't spend too much time talking about, but I think it's important that we should know, are truly vital corrections to British nationality law that have excluded many British people from their rightful citizenship, and have done so for not only years, but indeed decades and for generations. And they've done so largely because of previous prejudices in British nationality law that used to only allow citizenship to be derived from fathers, so excluded mothers from passing on citizenship, and also refused to recognise the parentage, particularly the paternal parentage, of children born out of wedlock. And so people born in those circumstances where either it was their mother who was British but not their father, or although their father was British, he was not married to their mother, many people were born without British nationality in circumstances in which they would have been, and so in turn oftentimes unable to pass on that nationality to their children. This has had impacts in relation to British citizenship, which is now the nationality of the people of the United Kingdom, but also to other British nationalities, including, particularly for this bill, something called British Overseas Territories citizenship, which is basically the nationality of the territories that the UK has held on to after the end of empire, such places as Bermuda, Anguilla, the Cayman Islands, and several others. And there are many British people across the world then, and many British people in this country, who are without their citizenship because of these historical wrongs. We strongly support putting them right. And indeed, people who this affects have been campaigning for this to be put right for them and their descendants for very many years. And then it's important, therefore, that at least the first 8 clauses of this bill should come into law, because otherwise these injustices and exclusions will continue. In terms of the remainder of the bill, the greater part of it does indeed concern the asylum system and this country's attitude and treatment of refugees and of people seeking asylum. And I'm going to speak about several of the measures that relate to that, but I'm not going to manage to cover all of it because there is so much. It's fair to say that there is none of the content of this bill that concerns anyone seeking asylum of which Amnesty either approves or indeed is even modest in its determination to oppose. This bill, so far as it touches refugees and people seeking asylum, is an abomination. It is an affront to this country's international obligations under refugee law. It is a profound reneging, in fact, of our international law obligations. And beyond that, it is a dreadful message to send to the rest of the world, where I'm sorry to say, many other people seeking asylum and entitled to asylum are also regularly mistreated by the laws and practices of other states. Marina reminded us of some of the consequences of that when touching on the tragedy last week that cost 27 people's lives in the English Channel. Of course, it's not just at that border where people are regularly losing their lives. Most recently, perhaps, beyond the Channel, we've had the dreadful circumstances of people literally, including children, freezing to death at the border of Poland. And we similarly know, I'm sure by now, that literally thousands of people in recent years have died in the Mediterranean Sea, and indeed, although less well recorded, in the Saharan desert on journeys seeking safety from many places of persecution. It's important, therefore, that every nation that owes a duty to receive and provide protection to refugees shares in its obligation to do that. And this country does not share, and in fact hasn't done for a very long time. This bill is designed to ensure that this country does even less of that sharing. And it aims to do that in many ways. Firstly, it seeks to prevent refugees getting to this country or being admitted to its asylum system if they do. And one of the critical provisions in this bill, and I'm not going to give clause numbers, by the way, if anyone was looking for that, partly because as bills pass through Parliament, the numbering changes. And so if you learn the clause number today, the chances are that in a week or two, that might not be the clause number tomorrow. But there is provision in this bill to allow the Home Secretary to refuse to admit people who have arrived here and claimed asylum into this country's asylum system, and instead to seek to send them to another country for that country to take responsibility for their asylum claim. One of the very real injustices and harms of this provision is a practical one. Since this country receives very few people seeking asylum, not that you might realize that from much of the media attention and political attention, but actually we don't receive very many people into our asylum system. And so it's very difficult to understand why the government should think that countries who on the whole receive more people into their asylum systems, as for example do France and Germany and Spain and Italy and Greece, and if we're at least talking proportionately, as do nearly all countries, at least the relatively wealthy countries in the European Union, not to mention many other countries elsewhere. So why should any of these countries have any interest in receiving people into their systems from ours? And the reality is that they don't. And our government has been trying to push people back to European systems for much of the last year under rules that were introduced at the end of last year, and has thereby left thousands of people in this country who have claimed asylum, as they're entitled to do, in a limbo, wondering and waiting whether their claims will ever be decided, and if so, by whom. Of those thousands of people, some 7,000 people, in fact, over the course of the year, thus far, 10 people have been received back into the asylum system of another country. Some 2,000 people have eventually been admitted into the UK system. And then we can be sure that the great majority of the other 5,000 people, that will be the result for them too, after, of course, a great deal of delay and distress and worry for them. Apart from anything else, this does absolutely no good for the efficiency and effectiveness of the asylum system, which already has its own backlogs, and backlogs which are growing because of policies like this. And this bill seeks to entrench that policy in primary legislation as opposed to the immigration rules, and is one way by which our asylum system, very far from being fixed, is going to be made much more dysfunctional, inefficient, costly to the taxpayer, and indeed extremely distressing and harmful to the people who are subjected to it. If someone does manage to get into the asylum system, this bill includes provisions to make that system both much more bureaucratic in terms of formal demands of when they must submit evidence and explanation of their claims, but perhaps more importantly, much more penalizing of any failure to be able to keep up with these bureaucratic demands. And so there are provisions that essentially instruct decision makers at the Home Office, but also independent judges in the appeal system as to how much weight they must give to evidence and how they must approach questions of credibility against someone seeking asylum on the basis that perhaps they have declared something, according to the Home Secretary, later than they should have. This again is a wholly disastrous and stupid way to go about any asylum system. A decision maker, if you can trust them to make a decision, ought to be capable of evaluating what weight and credibility to give to evidence. That's a core part of their job in any individual case. Telling them in advance how to go about that only encourages them to preempt views, negative views, about the weight of evidence and the credibility of someone, which means that many refugees pass through the system disbelieved and excluded from the status to which they are entitled, which ultimately doesn't lead, for various reasons, to their being removed generally to the places where they face persecution, but more often leads to them living lives of deprivation, exclusion, and exploitation in this country. And also, for that matter, lives that cost the taxpayer more in terms of the asylum system, which is tasked to try and support or manage them, rather than allowing them to get on with their lives, having recognised them to have the status that in international law they do. This, I'm sorry to say, isn't the only effort at interfering with a proper and safe decision-making process. There are provisions to reintroduce what's called a fast-track appeal system in detention, which basically means you rush someone through both their initial decision and the appeal system at breakneck speed from a place of detention where they are inevitably under a great deal of stress and anxiety, and essentially make it extremely hard for them to put forward their case in a way in which it can be fully and fairly considered and their status properly identified. And at the end of rushing them through this system, what has happened in the past, and no doubt will happen in the future, is that they then languish for often months in detention, because just because you've managed to rush refusing their claim doesn't mean that you're any more capable of being speedy about doing anything about their presence in the country. And so people are left in limbo and anxiety in detention. This too, obviously, is something which we have opposed in the past, and it is very disturbing to see it being brought back into view through this legislation. I'm sure there's been much that has been said, and you will have read about, of so-called offshoring. Offshoring essentially refers to the idea of sending people to other countries to have their asylum claims processed and any appeal dealt with there before deciding what to do if it is shown that they are refugees. We are opposed to that. I'm bound to say that I think this is one provision that's very unlikely to result in any formal implementation in practice. One of the reasons for that, and I hope I'm not proved wrong, is that as Australia has seen with its truly abysmal and cruel policy of sending people seeking asylum to Manus Island and Nauru, is that it cost literally billions of pounds to persuade another country to receive a relatively small number of people whom the government doesn't want. And despite what the Australians will consistently tell us, people still arrive and seek asylum on your shores. It has been said that this country has been in talks with Albania about setting up such a system. It is noticeable that each time this has been apparently leaked to the British press, the Albanian government could not have been clearer that the stories are false and that it has no interest whatsoever in receiving people seeking asylum from this country. These are not the only ways of mistreating someone who arrives on your shore seeking asylum. And this bill also sets out to criminalize people's arrival and claiming of asylum. It is very important to know that anybody who wishes to seek asylum in the UK, and the UK is not dramatically different to any other place in this, that to seek asylum here, you must reach here first. You cannot ask for asylum to the UK unless you are in the UK, and that is long-standing Home Office policy. Our immigration rules set out all the visas that are available to anyone who wishes to see whether they have any entitlement to come or be permitted to come. Our immigration rules do not, and never have, included visas for people to come here to seek asylum. And if you come from any of the countries from which people are forced to flee persecution and conflict, you will find that you are on a country that is on the UK's visa list. In other words, you require a visa in order to travel here. That is a watertight system for ensuring that the only way that the vast majority of refugees can possibly seek asylum in this country is to do so by an unpermitted journey, usually with the aid of one or more smugglers, and often taking extreme risks all the way up to arrival on UK shores. However, it is the determination of our government by this bill to not only persist in that, but to punish people who go through what are often extremely traumatic journeys, and sometimes, as we've been reminded, fatal ones, for doing so. As UNHCR has reminded repeatedly parliamentarians in evidence that it is given time and again over the last few months, this is to do nothing more than punish people for exercising their legitimate right to seek asylum. The punishments now are to be extended to the prospect of potentially 4 years imprisonment. And the criminal offences provisions in this bill are to extend to penalising somebody who, for purely humanitarian reasons, assists someone to reach these shores to seek asylum. That includes potentially rescuing someone at sea and assisting them to reach shores. It also potentially includes, and probably much more significantly includes, people who find themselves identified, sometimes for completely arbitrary reasons, as in charge of the little inflatable on which they and others are travelling across the water in the hope of seeking asylum here. And being singled out as the poor soul who is taken to be the so-called ringleader puts the person, if this bill is passed, at least in principle, at risk of a life sentence. I should also emphasise that any of the offences that I've mentioned, if successfully prosecuted against a refugee, would be sufficient under the provisions in this bill to exclude them from being recognised as a refugee under British law altogether. None of that is compatible, needless to say, with our international obligations, and is a truly terrifying example of how to use the criminal law to prevent and deter and punish people for doing nothing more than exercising their basic human right to find safety from persecution. For the refugee who, despite all of this, manages somehow to get into and through the UK's asylum system and be formally identified as having the rights that they do in international law, the horrors and penalties of this bill are not done. Because for the great majority of refugees who must come by the dangerous journeys that I flagged, this bill promises to penalise them even after recognising them to have the right to asylum here. And it proposes to penalise them in a number of ways. Firstly, by providing them permission to stay for a much reduced period of time, which they will have to repeatedly beg, essentially, to extend over many, many years. The idea being they will be permitted to stay for 30 months, plus another 30 months, and possibly another 30 months, and possibly another 30 months, before there will be any consideration of whether they may be allowed to stay permanently. This will be extremely distressing and uncertain and unsettling for anyone subjected to it. It is also, to pick up a theme from earlier, a particularly stupid way to run a system that ministers say faces all sorts of challenges in being managed, because the last thing it is useful to do is require people to keep making new applications to justify their need for a continued stay, rather than allowing them from the beginning to settle, feel safe, become more integrated, and get on with their lives. And, if I can put it a bit crudely, stop bothering the asylum system with needing to reapply again and again. But there you go. That is one of the things that is proposed to be done, but not the only. Another way in which the refugee is to be penalised under this bill is by delaying or refusing altogether any right to family reunion. And apart from the distress that that is likely to cause someone in this country who is worried about their family overseas, or simply is feeling the distress of being separated from them, it is also likely to improve the business of smugglers and others by providing a whole new set of people who can be exploited on dangerous journeys, now seeking to reunite with their family members in circumstances where before they could actually apply for a visa and come by a safe and reasonable and managed system. The final way by which it is proposed to penalise refugees in these circumstances is, despite all of this, to also subject them to what are called no recourse to public funds conditions. So to say that they cannot seek ordinary welfare support if they are unable to find work to sustain themselves. Now, ministers have obviously declared that, of course, they would not impose such conditions if this would leave someone destitute. Now, again, apart from the obvious distress and harm this is going to cause by actually leaving many people homeless and destitute, and others trying to struggle not with the benefit system, which would be difficult enough, but firstly having to struggle with the Home Office system of having to make another application to the Home Office for a determination that, yes, okay, perhaps you are now destitute, so perhaps we can lift this prohibition on your permission to stay here. And of course, all that is doing is adding even more bureaucracy and cost to all the other myriad ways in which this bill is liable to make our asylum system far more costly and dysfunctional, as well as harmful to the people it is supposed to protect. Now, that is a bit of a whistle-stop tour of the refugee provisions, but I did want to flag very briefly that there are other provisions in this bill affecting other people, and affecting other people in very bad and dangerous ways. I'm not going to get through all of that because we'll want some time for questions, but I'm going to flag just a couple of examples. There is a relatively large section in this bill on what is referred to as modern slavery. That essentially refers to issues of human trafficking and human enslavement, in this instance in the UK. One of the disasters of this bill is to take a similarly hostile and bureaucratic attitude to the determination process for people who are identified as possible victims of modern slavery, as this bill takes for people trying to pursue their asylum claims. And so the prospect is that many more victims of modern slavery, even when initially identified, will be excluded from the protections to which they are entitled. Another group of people particularly harmed by this bill are people born and growing up in this country who were born here without any nationality at all and are stateless. And it is proposed in this bill to allow the Home Secretary to fail to act on her obligations to register children who have been born here and grow up here, without any nationality as British citizens, and to do so on the basis of her claim that their parents could act to ensure their children obtain a nationality someplace else. This is liable to leave many children stateless throughout their childhood in this country, at least for many years. And the final thing that I wanted to particularly flag, which again comes back to nationality law, is the rather late introduction to this bill of a measure to permit the Home Secretary to exercise powers she already has, which are already draconian in themselves, to strip some people of their British citizenship. The provision in this bill is to permit her to do this in secret, to not have to even tell the person that she is doing this or has done it, and so prevent the person from being able to take any action to challenge her decision and put it right if she has exercised her powers not only draconianly but contrary to our law, but also preventing the person from considering what risks they may now be at for thinking that they are British and have the protection of the UK government, when in fact they do not. It is an extremely dangerous power, as I say, belatedly introduced into the bill. And despite what I said right at the start, as to the very welcome first 8 clauses of this bill, which do make significant improvements to correct injustice in British nationality law, this late edition shows, I'm sorry to say, that our Home Office in particular continues to have very little understanding, let alone respect for, our citizenship, which is a peculiar thing to think of the government department, which is integral to recognising any British citizen as having that citizenship. That is a whistle-stop tour of the bill. There is quite a lot I've left out. I hope it's not been too much to handle, and I hope it's not been too little in terms of what I haven't touched on, but it does leave us with a little bit of time for some questions.